You type the prompt, the AI made the output, so you own it, right? Across 4 major legal systems, the answer is almost never the way you think. Hi, I'm Pavlo, almost 20 years working across jurisdictions on hard legal questions, intellectual property included, and AI has tested most of what I thought I knew about copyright. In the next 9 minutes or so, I'll show you what you actually own when you use AI. We'll start with something I found last month buried in the terms of a tool that I use. Grab a coffee. A few weeks ago, I used an AI music tool called Suno to create a soundtrack for this channel. A few hours of prompting, listening, refining. I wanted to use it commercially, so I paid for the subscription. Then, because years of legal practice leaves a mark, and because I just made a whole video telling you to run these terms through an AI before you trust them, I checked Suno's actual terms of service myself. Here's what I found, word for word from Suno's current terms. Let's have a look at it together. Line 1. Suno gives you their rights. Sounds great. Except this assumes Suno had rights in the first place, which the law hasn't actually confirmed yet. Line 2. Those rights are tied to your paid tier subscription. What happens when you cancel? Suno doesn't say. And these gaps may be not accidental. And line 3, this is the one Suno makes no representation or warranty that any copyright will vest in any output. Plain English, we're giving you the rights, but we're not promising rights exist. And that's one of the most elegantly honest pieces of corporate drafting I've read in a while. They're telling you what they're selling and what they're not, even if that's the same thing. And this isn't a Suno problem. Suno is actually being unusually clear. Most AI tools are vaguer, but the underlying issue is universal. If the tool itself can tell you whether copyright exists, who can? The answer depends on where in the world you ask. And that's where it gets interesting. Before we look at where copyright actually comes from, here's a famous case that already answered part of this question. In 2011, in an Indonesian forest, a crested macaque named Naruto picked up a wildlife photographer's camera and took a selfie. You might heard of this because it went viral, and a few years later, an animal rights organization sued on monkey's behalf, claiming Naruto owned the copyright. In 2018, the US Ninth Circuit ruled no, animals cannot hold copyright. The Copyright Act requires a human author. Now replace monkey with AI. The camera didn't own the photo, the monkey who pressed the button didn't own the photo, and the AI that generated your output doesn't own it either. The only question copyright ever asks is, who made the creative choices? And depending on where in the world you ask, the answer changes. Same work, same prompt, 4 countries where you might need to defend it, 4 different approaches. United Kingdom, the UK answered this question in 1988. Margaret Thatcher was still Prime Minister, and the committee quietly wrote Section 9.3 of the Copyright Design and Patents Act. It says, when a work is computer generated and there is no human author, the author is, and I'm quoting, the person by whom the arrangements necessary for the creation of work are undertaken. Plain English, the person who made the arrangements is the owner. But who is that? the person who prompted, the company that built the AI, both as joint authors. The dominant UK reading is the user. But the courts haven't put a final dot on this. At least I could not find one at the time of filming. The remarkable part, in 1988, Parliament tried to write a rule for something most lawyers couldn't even picture. Before GPT, before Suno, before a monkey could file a copyright case in a US court, but they tried. China. In November 2023, the Beijing Internet Court ruled in Li versus Liu that a person who made creative choices while prompting an AI image generator qualifies as the author of the output. But this is the first instance ruling, and Chinese law doesn't bind other courts to follow it. So if you prompted carefully, edited, selected, you're likely protected. But the evidence has to be there. United States, the strictest of the four. In January 2025, the US Copyright Office published its position. Here's the quote that matters. Prompts alone do not provide sufficient human control to make users of an AI system the authors of the output. Translation: type a prompt, hit enter, publish the result. The output likely has no copyright protection. Anyone can freely copy it. But edit, curate, arrange, refine. Your contribution starts to count. It's a sliding scale. European Union. The honest answer still being decided. European Union copyright law requires a work to be the author's own intellectual creation. That standard assumes a human maker. Whether AI output qualifies, no EU statute spells it out, and no top court has ruled. The EU's official answer right now, paraphrasing, we'll let you know. Until then, each member state interprets for itself. So, same AI, same prompting, same output. UK, likely yours. China, likely if you show the work. US depends on how much work you did beyond prompting. You will know in a year or two. And the scale of this, Gallup reports 45% of US employees now use AI at work regularly. Qualtrics found 63% of companies use AI to generate text and 36% for images. Millions of professionals building things with AI, most of them without any idea this question ever exists. There is a line attributed allegedly to Henry Ford saying that if he had asked customers what they wanted, they'd have said faster horses. AI is our faster horse moment for copyright law. The law was written for humans creating with tools. AI is a tool that creates, and the law hasn't caught up. Until it does, the risk sits with you. So, what do you actually do? Here is the single most important thing. If you do nothing else from this video, do this. Document your creative process. Prompts, iterations, selections, edits. Save the conversation. Screenshot it, export it. 2 minutes at the end of any AI session where you made something that matters. So why does it work? Because every one of those 4 jurisdictions, UK, China, US, EU, in their own way, but test for the same thing, it's human creative input. Documentation is your evidence. That's what I did with my Suno track. I've downloaded the full prompting history, every iteration, every choice I made, 2 minutes. Am I 100% certain that my track is copyrightable in every jurisdiction around the globe? No. but all the 4 jurisdictions recognize exactly that kind of evidence. I have a defensible position, and that's all that any professional creator ever has. And now to context. If you use AI at work, at your employer, use the tools your company provides and follow your company's AI policy. So your employer's legal team handles IP strategy. You don't need to figure out it on your own. And if you use AI for your own work, side business, freelance, personal brand, you're on your own. So save the session, edit meaningfully, know which jurisdiction matters if you ever need to defend your work. You're not trying to guarantee ownership, you're building a defensible position. You now know more about AI copyright than 99% of the people using these tools, and that's not just awareness, that's your advantage. This video isn't a legal advice. It's a high-level map of a landscape that every serious professional now needs to navigate. For anything genuinely business critical, talk to your qualified lawyer in your jurisdiction. At least now you know what to ask them. Next video, can AI steal your creative work? Over 70 copyright lawsuits are pending against AI companies. Anthropic recently settled one for $1.5 billion. And Europe's top court just held its first hearing on this exact question, like company versus Google. So the real fight, did these companies ever have the right to train on everything in the first place? And that's the other side of the story. Subscribe if you want to understand how the systems actually work, not how they're supposed to. See you there, and don't forget, you don't have to be a lawyer to protect what's legally yours.